Hello, Professor Tanzi. We'll
Good
just
afternoon. Ayush, can you hear me?
yes, sir, you're audible.
Excellent. We made it.
Yeah.
Good
So we'll just
afternoon, Aniruddha. I can't hear you.
Good afternoon.
In fact, I cannot hear anyone really.
Hello.
Can you try to speak?
yeah. Tanzi, we'll just start in a few minutes. The participants are just joining in. We'll just start in a couple of minutes.
I can hear you very well, Ayush. If I may call you Ayush.
Yeah.
Attila, the second person you can see on the screen is Sarthak. And he used to be my research assistant in the past.
Very nice meeting you.
He now practices in the Supreme Court.
Well, congratulations. So, apart from you, Aniruddha, that you must be based in London, the Adhyayan Foundation, where is it based?
It is based in New Delhi.
Right.
And
Very good evening to you, Professor Tanzi.
driving force is are both Sarthak and Ayush. Ayush was also my research assistant. They both came the same year to Geneva.
Ah, right. So they know a lot about international law now. Under your stewardship, no doubt they have learned a lot. You know, I'm a bit hesitant in the sense that I have to try not to be too technical and complicated for those young lawyers who may not be familiar with the case, and avoid being obvious for those who are very much in the know. And at the same time, as you may imagine, I have reasons suggesting caution.
Yes.
So I might end up not saying too much meaningful about the case, but I'll try to restrict my proper lecture as much as possible, so to allow a question as a lively as possible question and answer session.
Yes, and I think it's really about the policy rather than the substantive issues. So I don't think you may have to.
That is my slant. Is actually as agreed, but there may be curiosities here and there that impinge upon the actual niceties of the law, which was not really the point. I mean, litigating nice fine points was also part of the process and served the purpose.
I must say I was very much remembering you because I was reading an article you wrote a long time back about enforcement of ICJ decisions.
All right. Yes, it was long ago.
Yeah.
Very long.
Still very contemporary.
Is
It will
it?
continue to be so.
Well, I'm glad to hear that.
Sarthak, I suppose we can start.
Yes.
Yeah, we can begin.
Okay. Well,
A very warm greetings to our guests, viewers, and students attending this lecture series from different parts of the world. I am Sarthak Raizada, and I welcome you all to the inaugural lecture of the Chanakya International Law Lecture Series by Professor Attila Tanzi, jointly organized by the Adhyayan Foundation for Policy and Research and the International Law Forum. Before we welcome our guests for the evening, we want to tell you that the inspiration behind this lecture series, as the name suggests, comes from Chanakya himself, who played an instrumental role in growth and expansion of the great Mauryan Empire in India. His work, Arthashastra, remains one of the most outstanding sources on the principles of polity. Little, however, is discussed about the relevance of Chanakya's Arthashastra to international law because we tend to confine our inquiry about the development of the rules of international law to pre-19th century Europe only. One of the most remarkable features of Chanakya's Arthashastra is that it is a work containing government and administration, but also a systematic exposition of principles of inter-sovereign relations. Interestingly enough, the principles and doctrines contained in Arthashastra on the laws of nations were expounded much before Grotius came to be recognized for conceiving them. We hope that in future the impact of Chanakya traditions and principles on the development of international law is also attempted. Among the dignitaries present with us today, we have Dr. Anirudh Rajput, member of the United Nations International Law Commission, who mooted the idea behind Chanakya International Law Lecture Series. He has been a constant source of motivation and inspiration in the founding of this project. We welcome you, Dr. Rajput, and invite you to say a few words regarding the significance of this lecture series for international law and the community of scholars practicing in this field. Dr. Rajput, please.
Thank you very much, Sarthak. I'm not going to take more than a couple of minutes to give a brief background and say thank you to the speaker and all the participants. First and foremost, Sarthak gave a very good introduction of why this lecture series is called Chanakya Lecture Series. Interestingly, the Montevideo Convention provides for 4 criteria of statehood, but Chanakya provides for 7 criteria of statehood in Arthashastra. And one of them is indeed recognition, which the international community is still struggling how to place it. So indeed, there is much more in this traditional wisdom of Arthashastra which can help us understand modern-day international relations and the kind of international relations we want to have in the future, and peaceful international relations between states. And with that goal in mind, we thought of having this lecture series where we could get international speak to scholars and practitioners who are primarily from India, but not limited to India, who have interest in India, who have some relation to India, and try to have a conversation amongst international experts and Indian international lawyers. An effort to create a community of international lawyers where you can share your views freely, understand and emphasize the value of international law in today's world beyond rhetorics and beyond criticism, and see how it can take the international community forward. And with view in mind, we are extremely lucky, I think, to have Professor Attila Tanzi to deliver this first inaugural lecture of the Chanakya Lecture Series, because he's going to highlight how 2 old friends who have something of a difficult situation without contemplation, and how these two old friends can resolve these disputes, which may take a political nature, through international dispute resolution processes in a peaceful manner, to retain their relationship and to enhance the international rule of law. It represents the commitments of these two big states, because they both are big and powerful in their own respective places. Despite that, not to resort to power politics, but to resort to international rule of law. So this is indeed a sterling example of how disputes could. I must also thank all of you who have decided to take out time to come to this lecture series and to listen to Professor Tanzi. In fact, the idea was to have Professor Tanzi, because his name itself would attract a lot of attention and crowd. So we are in a sense banking on his reputation, and we are glad to see that so many of you have joined us. I'm also equally pleased that some leading international law experts like Mr. M.K. Rao, former legal advisor of Permanent Mission of India, also consultant to the Ministry of Foreign Affairs, sitting Secretary General of ISIL, and Dr. Kazi Atilla, the Deputy Director of the Legal Department of Ministry of Justice, is here. So I'm grateful to them and many others, eminent personalities, all of whom I can't name, because if I name, then I'll be eating into Professor Tanzi's time. So I'll stop there. Thank you all, and in particular, thank Professor Tanzi for really taking time out and be ready to share some important insights from each side, from the other side. Thank you so much.
Thank you, Aniruddha, so very much, in the first place, for promoting this greatly appreciated invitation. Your kind and generous words, and for setting the scene of my lecture in the best possible way. But before I start my lecture, I wish to thank warmly the Adhyayan, and apologize for my very bad pronunciation, the Adhyayan Foundation and the International Law Forum, Sartak, for the learned and extremely useful introduction of the figure of Chanakya, which makes me even more proud to give this inaugural lecture series. I feel humbled and privileged truly to do so, and thus to be able to address young and promising, mostly Indian legal minds during this lecture, and to interact with them afterwards. Allow me to make a few preliminary precisions and general considerations, very much in line with the introduction made by Dr. Rajput. And primarily, I would like to say on a personal note, I am generally inclined to avoid comment public upon awards concerning cases in which I have been involved. But today I feel no particular sense of hesitation to speak about the Enrica Lexie case, subject to two caveats and conditions, which I'll try and stick to. First, as a positivist lawyer, I will not forget that the award which we are going to discuss today is the end product of a process based on the consent of both parties, as expressed by their ratification of UNCLOS. Whilst this would provide sufficient legal and policy ground for the final and binding character of the award as a piece of res judicata, both parties have reiterated their consent to arbitration by their active cooperation with the arbitration tribunal and with each other throughout all the phases of the proceedings. And this is not contradicted by the intense adversarial nature of the position taken by the parties during the proceedings. and thus the presentation by the opposing counsel of finely argued conflicting arguments, both of law and often of fact. Now, in fact, against this premise, it is not for me today to lecture by commenting critically or in support of any given finding in the award, according as to whether it was against or in favor of the party which had instructed me and my country. I may illustrate the main lines of the arbitral decisions without passing judgment, even though academically, as it were, or on such findings. Far from my intention. I may perhaps happen to lightly comment on certain pieces of reasoning, but never on any parts of the decision such reasoning brought the tribunal to. My second caveat, and as anticipated very much in line with Dr. Rajput's setting the scene words, I will address the overall Enrica Lexie case as the epitome of how international adjudication, be it exercised by an arbitral tribunal or a permanent judicial body, is not necessarily to be considered as a means of dispute settlement fundamentally separate from the diplomatic settlement of disputes. On the contrary, I will argue, possibly substantiated by sound authorities, that international adjudication may serve precisely the same purpose of settling the dispute with a view to re-establishing and further enhancing the international good relations between old friends, technically disputing countries. Now, the coincidence between the adjudicative settlement of the dispute and the diplomatic settlement of the dispute may not be necessarily always the case. I may argue that the Enrica Lexie case represents an egregious example of a success story in that respect, one which enhances the rule of law in international relations, Chapter 6 of the United Nations Charter, as well as, if I may, Article 51 of the Indian Constitution for the relevant part, not just as a matter of axiomatic principle, but also from a realpolitik and utilitarian perspectives. As I see it, the Enrica Lexie case very much falls within the trend detected by the then president of the International Court of Justice in the early 1990s, Sir Robert Jennings, in his speech at the first conference of the members of the Permanent Court of Arbitration. It was 1993. He observed as follows, and I quote, "Resort to an international court or to an arbitration is no longer regarded as something outside and different from the ordinary context of relations between governments, but a device, a tool, which can be used in the course of diplomatic negotiations." End of quotation. Well, now, in general, such an integrated relationship, interaction, virtuous interaction between adjudicative and non-adjudicative means of dispute settlement seems to be particularly suitable to three kinds of sceneries that may be intertwined or overlapping, as the case may be. A, when the legal dispute in question is part of a wider politically complex dispute. B, when a given dispute requires, in part or in its entirety, the application of rules pertaining to distributive justice, as it were, such as in case of ostensibly conflicting interest in resources allocations or boundaries delimitations. C, when in combination or irrespective of the just mentioned sceneries and contexts, the dispute is simply one which would not allow the government to compromise the dispute. Under scenario A, one may recall the hostages crisis between Iran and the United States in 1979-1980. We recall the ICJ proceedings and the setting up of the Iran-United States Claims Tribunal as the end product of the good offices and mediation by the Algerian government. As we saw and still see, fortunately, resort to adjudicative means had not settled the overall dispute between the two countries, Iran and the United States. But the case may be made that they helped cooling off the tension throughout many years, helping avoiding confrontations of a more serious degree than the ones we have seen thus far. As to B, namely disputes concerning transboundary natural resources allocation or boundaries delimitations, here public opinion or the electorate, from the standpoint of political decision makers, would make any government pay a very high political price for compromising the dispute. By only an inch of the disputed land or a cubic meter of EEZ or continental platform or of the flow of a transboundary river. While the continuation of the dispute may involve considerable loss of profit, economic, political, tangible and intangible, due to the uncertain legal status of the disputed area or transboundary legal natural resources, the only way out of the stalemate is resort to impartial and authoritative third-party dispute settlement, as it were. The third, letter C scenery, is the one within which I see the Enrica Lexie case falling, namely one of unfeasibility to come down to the root of negotiation, even though we were not under the circumstances characterizing the first two sceneries. In the Enrica Lexie case, there was an obvious problem of popular opinion since the politicization of the incident had escalated in both countries. But next to that, or more than that, from a lawyerly point of view, there was an insuperable legal impediment, namely that in India the case was pending before the Supreme Court. And after the January 2013 decision by the latter, the Supreme Court, the Marines would be tried by a specialized court whose constitution was underway. Now, given the separation of powers and the independence of the judiciary from the executive in India as much as in Italy and in all civilized countries, there was very little or nothing that the government of India, in its best of intentions, could do to allow a negotiated settlement and take responsibility for it. The pursuit of an amicable settlement for 3 years involved the payment of a fairly high toll to the politicization of the unfortunate incident on both sides, on top of the sadness for its victims. That was certainly the case for the Italian government, which has been long under harsh pressure from the public opinion and the opposition parties for not reaching swiftly a successful solution to the case. And I suppose a high toll was paid by India on different grounds, I guess. I presume such grounds may have included the suspension of cooperative attitude by Italy, also through the European Union, which would otherwise always be fully supportive of the Indian diplomatic goals, including in multilateral contexts. If anything else, from a loyalist standpoint, that kind of diplomatic ping pong with a bit of ding dong at times between February 2012 and May 2015 served to Italy to prepare the ground in order to fulfill two admissibility requirements before the then would-be arbitration tribunal, and prior to that, before the ECLS, in order to demonstrate prima facie jurisdiction in order to request and obtain provisional measures. That is, those two admissibility requirements are A, the existence of an international dispute, and B, the exhaustion to no avail of exchanges of views aimed at reaching its settlement by negotiation, or to find out the possibility of other mutually agreeable means of dispute settlement, such requirement being provided for under Article 283 of UNCLOS. Now, moving to the more legal part of the story, and we have already seen that the legal technical machinery was part of an overall wider dimension of diplomatic appropriateness, as already argued in my first part of the lecture. Italy broke down its case basically into three claims, with a view to persuading the arbitrators that it had exclusive penal jurisdiction over the two accused Marines, and that the Indian courts and tribunals lacked jurisdiction over them. In summary, the first claim, which Italy argued, possibly bravely, was that India's legislation on which India's conduct vis-à-vis Enrica Lexie and the Marines was based, namely the 1976 Maritime Zones Act and the 1981 notification, was incompatible with UNCLOS and represented an infringement of it. The second tier of the Italian defense was consisting of the claim that India was in breach of Part 7 of UNCLOS on high seas, with special regard to Article 87 on freedom of the high seas, Article 92 on status of ships, Article 97 on penal jurisdiction in matters of collisions or any other incident of navigations, which would in combination provide and individually allegedly provide exclusive jurisdiction to the flag state and not to the coastal state. When we also pleaded Article 100 on the duty to cooperate in the repression of piracy and Article 300 on good faith. The third tier was that by the same conduct, India violated the immunity of their Marines. Now, Italy argued that the real issue in the case and the object of the claim was the determination of which state was entitled under UNCLOS to exercise jurisdiction over the two Marines in relation to the incident, and concluded that it was self-evident that the core of the dispute concerned the interpretation and application of the convention. On the other hand, India argued, on the contrary, that the core issue, the real subject matter of the dispute, was not one concerning the interpretation or application of the convention, but rather the issue of immunity, which was allegedly beyond the scope of the jurisdiction of the tribunal, because it was beyond the scope of application of UNCLOS. Thus, based on Chagos, the case between Mauritius versus United Kingdom, India argued that an incidental connection between the core of the dispute outside the scope of the convention, with some incidental matters regulated by the convention, was insufficient to bring the dispute as a whole within the boundaries of the tribunal's jurisdiction, as generally curtailed by Article 288 of UNCLOS. We submitted that the Marines enjoyed immunity from Indian criminal jurisdiction actually concerned interpretation and application of the convention, based on language to be found in Article 2, Paragraph 3, 56, Paragraph 2, and Article 58, Paragraph 2. According to these provisions, as the applicant saw it, UNCLOS imported the customary rule on immunity by reference or by renvoi. The tribunal rejected Italy's claim based on those provisions. And it bears singling out that the stand of the tribunal on this point, as you may find it at paragraph 809, observes as follows, and I quote, "The arbitral tribunal considers that while the convention may not provide a basis for entertaining an independent immunity claim under general international law, the arbitral tribunal's competence extends to the determination of the issue of immunity of the Marines that necessarily arises as an incidental question in the application of the convention." End of quotation. Well, in sum, the issue of jurisdiction by the tribunal over the claim of immunity proved key to the case, but was not deemed by the tribunal to be the real issue of the case or the object of the main claim, whereby the convention would be merely incidental to it. It rather found the contrary. As the crux of the matter on the merits concerning the claims based on UNCLOS, the tribunal reached two fundamental findings. First, it rejected virtually all claims advanced by Italy that I just referred to a minute ago. Second, it found for India, with respect to its counterclaims, alleging that Italy was responsible for the Enrica Lexie infringement of the freedom of the high seas and the right of navigation with respect to the Centenary, and that this was in breach of Articles 87, Paragraph 1, and 90 of UNCLOS, respectively. Based on such finding, the tribunal came down to its key decision at paragraph 839 as follows, and I quote, "The tribunal found that based on Article 58, Paragraph 2 and Article 92, each party has exclusive jurisdiction over their respective ship involved in the incident, namely Italy over the Enrica Lexie and India over the Centenary. The parties, therefore, have concurrent jurisdiction over the incident." End of quotation. Now, against the background of concurrent jurisdiction, here immunity comes into play, thus precluding the exercise of criminal jurisdiction by the Indian judiciary. Now, in conclusion, as I see it, the award, with a fair degree of legal reasoning, has not only decided the dispute on all the legal issues raised by the parties, but it has also definitely settled the dispute. And as I alluded before, and as we unfortunately know, it is not always necessarily the case that an adjudicative decision brings the parties to the final settlement of their dispute. Therefore, this can be seen, as already alluded again, as the most successful aspect of the arbitration proceedings in question. By setting aside Italy's claims of the alleged breach of the freedom of navigation in the EEZ by India's sheer pieces of legislation of 1976 and 1981, which provided for certain rights of sovereignty beyond economic rights over parts of the high seas, and by rejecting also Italy's claim that India had materially breached the Enrica Lexie's freedom of navigation, also based on factual evidence as it emerged during oral proceedings, the tribunal has preserved the legal protection customarily afforded to sovereign interests of coastal states. Allow me to say, to an extent that cannot be said to be found in the Norster judgment by the English. At the same time, it can in no way be argued that the upholding of the prerogatives, the legal prerogatives of coastal states, as just mentioned, was couched in the award in any way that would sacrifice or even unduly constrain the principle of freedom of navigation. On the contrary, the award has preserved the principle at hand in most balanced terms with respect to the rights of coastal states. It did so first by entertaining India's counterclaims, and second, by finding the infringement by Italy of the freedom of the high seas and the right of navigation with respect to the centenary in breach of Articles 87 and 90 of the UNCLOS. This kind of application of law by the tribunal may prove beneficial in the long term to both India and Italy, as both coastal and flat states at the same time. Along the same lines of policy considerations, the application of the immunity of the Marines in the instant case may bode well for the enhancement of the legal protection of military and state officials abroad, both Italians and Indians, sometime in the future. This will not provide a precedent that may run counter to military institutional interests of our countries in the future. It bears noting that the application of the immunity in question has not led, and this is very important as a matter of justice next to law, has not led either to impunity or to lack of remedy for the relatives of the victims. On the one hand, the award takes note of the commitment made by Italy in the course of the proceedings to resume its criminal investigation. In fact, the competent public prosecutor in Rome has already resumed the investigation. On the other hand, next to the declaratory assertment of the wrongfulness of the conduct attributed to Italy in breach of Article 87 and 90 as a form of satisfaction for the material damage arising out of breach of those provisions, the tribunal awarded the payment of compensation by Italy for the ensuing loss of life, physical harm, material damage to the Centenary, and moral harm suffered by the captain and crew of the Centenary. Concluding by referring back to the initial emphasis on the integrated approach to adjudicative and negotiated dispute settlement, increasingly used in international practice and case law, it bears noting that the award encourages the parties to engage in consultations with a view to reaching a negotiated, mutually agreeable amount for the compensation due. I will stop there, having been brief, in order to allow for a wider interaction in the question and answer session. And I thank you very much for your attention and for bearing with me. I cannot hear. Perhaps you have to unmute yourself, Sata.
Thank you, Professor Tanzi, for giving us a bird's eye view of the Lexi dispute and the wonderful explanation of the dispute between Italy and India regarding the interpretation and application of the convention versus the question of immunity. This session was truly very insightful for all of us. From the participants, we have a few questions. If I may spell them out, and you can accordingly answer them for the curious students that we have with us today. So the first question, Professor Tanzi, is, as opposed to the granular approach adopted by the ICJ in the certain Iranian assets case and criminal proceedings cases, do you believe that the PCA stretched the boundaries of its jurisdiction by addressing the incidental question of immunity and relevant compromissory clauses?
Well, Sartak, I thank you very much for this question, and through you, I thank those who have delivered that question through you. Well, you probably may guess my answer to that question on the basis of what I've already said, but I'm pleased to receive this question because it allows me to go a little bit deeper into the issue and put it in a wider adjudicative context. This comparative approach, which I have actually seen in the doctrine on a blog last summer. You know, once you've been involved in a case, you become predatory and very hungry to see the comments of the academic world about something you have been practicing. And particularly there was one article by co-authored by Ms. Metimaki and Professor Hams. Now, well, let me just in the first place reiterate that I believe and that it is not for me to approve of it, but there was certainly, having seen how the dispute was built upon since the occurrence of the incident. So there was certainly a principal claim revolving around the interpretation and application of anglers. From the occurrence of the incident until prior to the filing of the application. And this is important also from a procedural standpoint, whereby you couldn't say that Italy has been pleading in diplomatic exchanges throughout 3 years before filing the application, immunity, and then for purposes of expediency and jurisdiction introduces in the application claims pertaining to the anglers. Actually, I remember, and actually, yes, I saw them in the making, so very many note verbals in which the first ground for the invocation of settlement of the dispute was primarily a claim of alleged exclusive jurisdiction under the law of the sea and residually immunity. I said, allow me to put, if I have the time, Sartak, to put these considerations in a wider context pertaining to the adjudicative function of any adjudicative body, be it a pre-established court or an arbitration tribunal. They all basically apply Article 38, paragraph 1. We normally refer to Article 38, paragraph 1 of the ICJ statute for purposes of identifying the sources of the applicable law apart from that chosen specifically by the disputing parties. But it is very important to reflect to the basics that emerge from Article 31. That is the function of the court, which is the function of any interstate adjudicative body. It's very banal, but it's often lost sight of, particularly by academicians, scholars. Let me quote, "To decide, in accordance with international law, such disputes as are submitted to it," unquote. That is to say that the main function of an adjudicative body is to decide the dispute as such and as a whole in accordance with the law, based on the fact-specific features which make up any given dispute before it. And I will turn to the specificities of this dispute as opposed to the two cases that have been mentioned, that have been decided by the ICJ in an apparently conflicting way. I don't see conflict there, and I will explain it in a minute. But let me complete this general point in the sense that the adjudicative function is one, to apply the law to the jurisdictional issues and to the merits before it, not in a vacuum, or to each individual claim technically one by one in watertight separation from the whole of the dispute, which the parties have asked the court or tribunal to decide. So I would like indeed to single out that in both certain Iranian assets case and the immunities and criminal proceedings between Equatorial Guinea and France, immunity appeared as a discrete self-standing claim, differently from the Enrica Lexie case, where it was inextricably linked but subservient to the main claim of exclusive versus concurrent jurisdiction claim under UNCLOS. I suppose that this accounts for the observation that Metimaki and Professor Tam made, that the tribunal in the Enrica Lexie followed a methodologically different approach from that followed by the ICJ in the two cases in question. Well, I argue that the different methodological choices much depend not on a methodological different taste by the tribunal, but depending on the different disputed facts and the applicable law in the different, which is different in the cases in question. The ICJ went down the route of addressing the separate ground of jurisdiction to entertain immunity claim as a separate claim, looking inter alia at whether the disputed treaty contained a rule on immunity through reference by incorporation. Given the specificity of the case and the disputed treaty containing the compromissory clause, the ICJ had to render the question of jurisdiction over the application of the rule of immunity as subservient to the question whether the rule on immunity was part of the applicable law. In the Enrica Lexie, the tribunal did exactly the reverse, but not as a matter of taste. I suppose it was bound to do so for the very inextricable link between the exercise of penal jurisdiction under UNCLOS and the question of immunity. And it was also bound to do so once it has ascertained its jurisdiction under Article 293 of UNCLOS, even if the award does not mention Article 293 in so many words. But it does not mean that tribunal may not do the right thing according to a prescription without mentioning it in so many words. The tribunal in Enrica Lexie addressed the dispute before it basically as one of interpretation of the law of the sea, where the law of the sea issues bearing on the exercise of jurisdiction were inextricably intertwined with the issue of functional immunity of the accused. Clearly, the dispute arose out of conduct and facts at sea, which squarely fell within the scope of UNCLOS. That implied that the dispute fell within the tribunal's jurisdiction. Once ascertained its jurisdiction over the dispute, and there came to apply the UNCLOS, the tribunal, according to its own words, applied the customary rule on immunity because, I quote, it necessarily arises as an incidental question in the application of the Constitution. If I may illustrate the difference between the Enrica Lexie and certain Iranian assets, in the latter case, the ICJ was confronted with immunity playing out as the main argument to substantiate a breach of rights and duties stemming from the disputed treaty. In the Enrica Lexie, on the contrary, the ascertainment of rights and duties stemming from UNCLOS was the core of the dispute, but the interpretation and application of the rule on immunity was conditional upon the interpretation and application of such rights and duties deriving from UNCLOS, notably the exercise of domestic jurisdiction, which the tribunal found to be concurrent. The same difference applied with respect to the immunities and criminal proceedings case between Equatorial Guinea and France. There again, the breach of immunity was the principal self-standing argument alleging the breach of the convention. It should not provide for any rule on jurisdictional immunity. So there I see that, and I stop here, and I'm sorry for having been too long, but as I see it, that what has been emphasized as to be a different methodological approach between the Enrica Lexie Tribunal on the one hand and the International Court of Justice is not a contradictory attitude. A different methodology, probably different priorities on the basis of different priorities in the very dispute. So I don't think that as I see it, in my humble opinion, that the tribunal had to be any more granular. There was no need for more granularity. I think it was quite thorough, but that's my view.
Thank you, Professor Tanzi. So the second question for you, and I think you've also touched upon this when you were speaking. So the second question is, Professor Tanzi, considering extradition and forum convenience are diplomatically and legally sensitive issues, how is it best for the courts and parties to handle them?
Well, the reason why it was very difficult or impossible to compromise the dispute apart from a matter of independence of the judiciary was certainly to do with the fact that the exercise of criminal jurisdiction by the judiciary pertains to the core of the national sovereignty, and there a unilateral approach by domestic judges, courts and tribunals is not only understandable, is constitutionally inevitable. So when you have necessarily under constitutional considerations such a unilateral approach to the exercise of domestic judicial sovereignty, jurisdiction, it is very difficult that there is any room for anything other than a unilateral judicial domestic approach to the matter. So what is convenience for one judge in one country may not be considered as convenient in another country. So that is why, as you he or she who put this question indicated is diplomatically and legally. It is diplomatically sensitive because it is legally very, very sensitive. And that is where, if you want to have any settlement, you realize that this is an extra reason why a dispute over the exercise of domestic criminal jurisdiction may not be compromised, and the best way to have it settled is to ask a third party. And in this case, I don't see much room for mediation, conciliation, but an adjudicative means of dispute settlement. I'll stop there.
Thank you, Professor Tanzi. So the third question that we have received is, and this is mostly a policy question that the students want to ask, what are the future prospects in the law of sea to tackle cases similar to Enrica Lexie, and how does it affect the formulation of policies by the government?
Right. Well, let me say that in the first place, as I see it, this is a very specific case, very much linked to reaction by the international community, also prompted by a number of resolutions by the Security Council to defend, protect international trade and navigation, commerce and navigation from piracy. We very much hope that the danger posed by piracy worldwide, if it has not been definitely settled, will be down. So vessel protection detachment units will no longer be utilized, so will no longer be necessary. Clearly, the principles that have been interpreted and applied in this very peculiar kind of dispute, the way they have been interpreted and applied, may have an impact in the future. And as you alluded, I have already indicated in positive terms, as I see it, that the apparently conflicting principles have been perfectly reconciled and preserved, of freedom of navigation on the one hand under Article 87, and the sovereign rights of coastal states. In a way, the Enrica Lexie Award, which was handed down after the Hitlers rendered the Nostra judgment, in a way fine-tuned, sort of mitigated the position of Hitlers, which provided a strong affirmation of the freedom of navigation, constraining to a highly significant extent the exercise of jurisdiction by coastal states. So the posterior later decision is welcome. And I was lead counsel in the Nostra case brought by Panama against Italy. And it was a very difficult task to plead the role and defend the role of Italy as a coastal state, when in the Enrica Lexie case we were defending the rights of the flag state. But if we combine the Nostra judgment with the mitigation effects of the Enrica Lexie, I think the policy the policy prospects of formation of state policies, particularly in that area of those oceans and seas where we know troubled waters, so to say, it is important to strike a balance and elaborate policies that rely on the authority of the law. And I think that a number of general statements that have been made can be found in the Enrica Lexie Award, can substantiate, corroborate the soundness in law of state-made policy, and defend, ground the solidity of national policy in the field of the law of the sea. And as far as the immunity is concerned, I think, as I already alluded, I mean, when you have military missions abroad, when you have state officials abroad, I mean, you have individuals who may make mistakes. They have to be held accountable, certainly, but it is appropriate that the old traditional rule, whereby they will be tried by the state of which they are organs, is probably the best way forward. If in terms of intellectual and legal conciliation, we used during our pleadings to quote a rather enlightened statement by the Indian delegation in the Sixth Committee, and I have it. I almost have it in my pocket. I've had it in my pocket for many years. So the Indian, and I quote, the Indian delegation agreed with the special rapporteur. It was Judge Kolodkin at the time, on the draft articles on immunity from criminal jurisdiction of states official. The Indian delegation agreed with the special rapporteur that the immunity of a state official from foreign criminal jurisdiction was a generally accepted norm, and that any exceptions needed to be proved. It also agreed that the possibility of lifting immunity in criminal proceedings should be considered either at the initial stage of the process or at the pre-trial stage. Cooperation between states on matters relating to the immunity of state officials should be enhanced, and it should be recognized that the right to waive immunity was vested in the state, not the official, unquote. So they're a rather protective approach, which I think is institutionally appropriate, and it preserves peaceful relations between states. I think that is what history and practice has showed all along. I stop there.
Thank you, Professor Tanzi, for the replies that you gave with such incisiveness to all the questions from the participants. Since we already have Dr. Rajput present with us, I would request him to also offer his remarks on the discussion we have had today. So, Dr. Rajput, please.
Very honest, we have a saying in Sanskrit which is called Dugdha Sharkara Yog, milk and sugar. So this is a Dugdha Sharkara Yog, and after you have tasted such a sweet dessert, I don't think I should spoil the discussion in any manner, except for thanking and continuing my conversation with Professor Tanzi, which has been an ongoing process. Thank you.
I would now invite Mr. Ayush Rastogi to give a vote of thanks.
First of all, we are very thankful to Professor Tanzi for delivering this inaugural lecture. Dr. Tanzi has been very swift with us, and he has been throughout in support with us and cooperated a lot with us for this session. So first of all, I'd like to thank him. Also, we are very thankful to Dr. Rajput for being the driving force behind this initiative to foster a community of international law enthusiasts and professionals in India. We also have with us today Mr. Rao, the Secretary of the ISIL, Kasi Batla from the Department of Legal Affairs, and we also have several professors who have joined us from National Law University, Delhi, ISIL, and several other institutions. We are grateful to you, to all of you, for your support to our initiative. So this session is merely the first in a series of several events that we have planned centering around international law. Next month, we are planning to hold a session on careers in international law, wherein legal professionals working in the field of international law should try to guide students and professionals about the opportunities that exist in this field. I'm also thankful to all the participants who took their time out for this session. Also, a link to this session. This session is also uploaded on YouTube. So, any of you, if you've missed certain parts of it, because I can see some of you had joined during the course of the session, you're free to go back again and watch this session. Thank you so much.
If I may have for just for a good purpose, the last word, which is an extra word of gratitude, I want to pick from what you just said. To one of the aims of these events and this series is that of fostering the sense of community among international lawyers in England, in India. And if you allow me, apart from this brief or too long appearance, I may feel entitled to feel part of that community and beg to keep me and continue interacting and mutually enriching with our experiences and thinking. In the name of the memory of Chanakya? Chanakya, that I thank again Sartak for having made me discover this worthy, esteemed, learned individual. So thank you very, very, very much again. It was a pleasure to have spent some time with you, and I look forward to meeting you in person when this is over. Thank you very much. And again, many thanks, Dr. Rajput. Thank you very much to you all.
Thank you, everyone. With this, we come to the end of this session today. We hope you can join us for our next session as well. Thank you.